Hello and welcome everyone to the in-depth series of Drishti IAS English. My name is Pragya. In today's episode of In-Depth, we are going to discuss another important judgment that has been delivered by our Honorable Supreme Court of India in the electoral bonds case. So we all know that in a landmark judgment, the Honorable Supreme Court of India has struck down the electoral bond scheme as unconstitutional in nature and had given directions to comply with its order. So the title of our today's discussion is in the electoral bonds case, the Supreme Court has rejected the SBI's plea for extension of the deadline. In this discussion, we are firstly going to study about why did the SBI approach the Honorable Supreme Court of India. Then we are also going to understand who challenged the SBI's plea for extension of the deadline before the Honorable Supreme Court of India. And we are also going to examine the Supreme Court's stand in this regard. And lastly, we are going to understand and discuss a practice question for your prelims examination. So if I talk about the background of our today's topic or the news. So on March 4th, the State Bank of India approached the Honorable Supreme Court of India via a petition that it needs more time. So it prayed for extension of deadline that was given by the Honorable Supreme Court in that landmark case in which it struck down the electoral bonds scheme as unconstitutional. So to comply the Supreme Court's direction, SBI said that we need more time and asked the Supreme Court to extend the deadline to June 30. But this plea was rejected by the Honorable Supreme Court of India, and today is the day, that is March 12 is the day by which the SBI has to comply with the Supreme Court's directions. So this brings us to the moot point of our today's discussion, that what prompted the State Bank of India to approach the Honorable Supreme Court of India for extension of deadline. So the court had ordered SBI to submit to the ECI by March 6 the details of the electoral bonds purchased since 12 April 2019 till date. And what are these details? These details comprised of the date of purchase, purchaser's name, denomination of the electoral bond, denomination of the electoral bond, and the political party. Name to which this electoral bond was agreed to or was sent to. Okay, so we all know that what are electoral bonds? They are anonymous instruments through which political parties use to get their donations. And in a recent landmark case, the Supreme Court has struck down this scheme as unconstitutional because it said that the voters have a right to know under Article 19 Clause A of the Indian Constitution. So the SBI was directed to comply with these details, that it was bound to disclose these details by March 6 to the Election Commission of India. SBI was also directed to disclose details of each electoral bond encashed by political parties, which shall include the date of encashment and the denomination of the electoral bond. So not only the details, but it had also to disclose that yes, the date of encashment if the political party had encashed the electoral bond, okay, and the denomination of the bond which was encashed by the political party. Moving forward, the State Bank of India claimed that information on donors, that those are the purchasers, and recipients was maintained in two separate silos, and therefore the process of matching each individual bond purchased with the bond encashed by a political party would definitely take time. So this is basically a tallying exercise. Each electoral bond had a very unique number which could be only visible in under certain light and certain circumstances. So the SBI is claiming that they have not stored this record digitally. They have stored it in physical form so as to maintain the privacy and secrecy of the electoral bonds, and that is why it would require them time to actually tally the data with the purchaser's name and the actual name on the electoral bond, and that is why they were seeking this extension of deadline. Moving forward, let us examine who approached the Supreme Court regarding this SBI's plea for extension of deadline. So basically, the Communist Party of India, Marxist, and the Association for Democratic Reforms filed contempt petitions against the State Bank of India before the Honorable Supreme Court of India. So what is a contempt petition? It is filed under the Contempt of Courts Act, okay, and it alleges that yes, see, you have given these directions to this particular person and that particular person is willfully disobeying your directions, and that is why they are in contempt of your judgment. They are not following whatever you have directed them to follow. So this is basically the meaning of contempt. That means you are willfully disobeying a judgment that has been given by a court, okay, and that judgment must be given against you. So a contempt petition was filed before the Honorable Supreme Court of India with respect to the SBI, and it has alleged that the SBI was trying to willfully disobey the Supreme Court's directives in that landmark case. Not only this, it was playing a delay tactics. So the petitioners also said that why did SBI wait just 2 days before the deadline to file or to approach the Supreme Court or to file the petition. So all of this is a part of just delaying the tactics so that the general elections which are supposed to or are due in May could be avoided, and the SBI would have disclosed the electoral bonds persons and the date of the purchaser, name of the purchaser after the general election. So this was all alleged by the petitioners before the Honorable Supreme Court of India. Moving forward, the petitioners claim that SBI deliberately misinterpreted the court's directions as the judgment did not maintain a tallying of each bond purchased against redeemed bonds by political parties. So this was being prayed by the SBI in its petition that yes, we have to conduct a tallying exercise, otherwise we will be liable legally. So the petitioners in this case who approached the Supreme Court against SBI said that this is just a willful misconstruction of the directives that were given by the Honorable Supreme Court of India in that landmark case. Moving forward, the court only required the release of specific details such as purchaser information and details of political parties that received and encashed the bonds information, and this information is readily available with the State Bank of India. This was being argued by the petitioners before the Honorable Supreme Court of India. Even if a tallying exercise was necessary, SBI failed to provide sufficient reasons for why it would require an extension of over 3 months for conducting this tallying exercise. So in crux, all of these arguments are related to willful disobedience of the Supreme Court ruling, then delay in tactics, okay, then this willful misconstruction of the directives, and no cogent reason for asking the extension of the deadlines. So these are the summary of the arguments that were put forward against the State Bank of India. Now let us proceed to understand the Supreme Court's stand. Okay, so the Supreme Court in this case specifically asked the SBI that okay, no matter the location, you conducted a KYC process. Whenever someone used to donate in form of electoral bonds, the SBI conducted a KYC process. So KYC process is know your customer process. So no matter the location, you have the information readily available, but you are keeping it under a sealed cover. Okay. SBI was not required to match the bonds purchased to those encashed by political parties. It was simply to submit the details that were highlighted by the Honorable Supreme Court in its judgment. Simply the date of the purchase, denomination, name of the purchaser, the political party name, and if the political party has encashed those electoral bonds, then that was also to be disclosed by the SBI to the Election Commission of India. So, as per the Supreme Court stands, by March 15, 5 p.m, all of these information or details should be available on the Election Commission of India's website. And if the SBI this time fails to obey the Supreme Court's order, then only it will be liable for contempt. As of now, no action has been taken against the State Bank of India for contempt of the Supreme Court's directions. So with this, we come to a conclusion of our today's discussion. We have seen that why did the State Bank of India approach the Honorable Supreme Court. We have also seen the crux of the arguments that were put against the SBI's plea. We have also seen what the Supreme Court has said or observed in this case, and why, on what grounds it has rejected the SBI's plea for extension of the deadline. And now let us see a practice question for your prelims examination. So the question is, which article of the Constitution deals with the appellate jurisdiction of the Supreme Court in relation with the constitutional cases? Your options are: option A is Article 134, option B is Article 131, option C is Article 132, and option D is Article 132 read with Article 134 Clause A. So this answer will be given by you to me in the comment box below. I hope this session was insightful for you. If you have any feedback regarding this session, you can drop it in the comment box below. If you liked today's video and found it to be helpful, kindly like the video and subscribe to our channel for more such interesting updates. Thank you.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.